Hello and welcome everyone. Jen here from Female Fusion, and I am joined by the fabulous Bianca Gracias, who is the managing partner of Crimson Legal here in the UAE. And today we are talking about everything confidentiality agreements and how that helps you build trust in your business. Welcome to Female Fusion today, Bianca.
Thank you so much. I'm really excited to be here and talk about everything that is secretive and not so secretive.
Well, I am so pleased to have you here because it's one of these things that we talk a lot about within Female Fusion and around entrepreneurship. And sometimes people kind of think, well, I don't need this. My business is growing. Confidentiality agreements really aren't important for me, especially if, maybe they're managing their money. But maybe you can tell me a little bit about what a confidentiality agreement is and why an SME needs a confidentiality agreement.
And that's a very good point you set across, because I do come across business owners who are quite negligent when it comes to confidential information. And very many times, business owners will say to me, I'm an open book. My team is a family. Everything runs very openly. And here, let me flip that question to you instead. What if I were to come to you as a business owner and say, well, Jen, you're running Female Fusion in your business. Does that mean then, since you run your business like an open book, that everything in your everything in your company can be shared in the public domain? So if everything in your
no. And I think probably like a lot of our members would agree as well that they wouldn't want everything shared in a public domain either, right?
Exactly. So if your answer is no or absolutely no, then the way you need to regulate that confidential information is by putting into place robust confidentiality agreements. Because if you want to share confidential information like your P&L statements, financial information, formulas, trade secrets, recipes, algorithms with other parties who are employees, consultants, suppliers, and you want them to know what is confidential information, what they can share and what they can't share. And that needs to be recorded and enforced through a confidentiality agreement, because there is no law created up until now, at least, that can magically record when you set up a business what could possibly be your confidential information.
Yeah, so important, right? And I guess, it comes down as well to, protecting your business, because you might have something that you wouldn't even expect that could happen in the future as well. And I know that I have had over, close to 3 decades of owning a business, that you always go into things with the best of intentions, but, you do end up having things that happen which could put your business at risk. And I'd be interested to know from you, from your perspective as a lawyer, how having a confidentiality agreement can protect your business. Maybe from any sort of breaches from people, or any legal disputes that you might have.
I think the biggest mistake we see in particular with not having confidentiality agreements or not understanding the importance of them is trust. We trust too easy in business arrangements or business transactions, and you can't really rely on trust, because my perception of confidential information, of what my obligations are with regards to your confidential information, could be very different to your perspective and understanding. So it is always important to record our perspectives or whatever we deem to be our arrangement on paper, so it's crystal clear what is confidential information, for how long we are going to keep it confidential, who we can share it with, and if at all things go south, how we enforce those provisions between ourselves.
Yeah, I mean, it's so important. When you were saying that as well, I was thinking about a number of situations that me as a business owner has faced over 3 decades, when you don't even think that something could potentially go wrong. And it's even things like having that information that you want to protect, and maybe you have somebody who's worked for you, either currently or in the past, who could maybe go and reveal that information that is meant to stay within your business. And if it's not clear to them, that they don't know if they should be sharing it or not.
Yeah, but also remember when your business is in the nascent phase, say you're an entrepreneur who's just starting out, you may not
You
have
don't
as
think
much
of that.
information, right? So you don't think of it, you
Right.
don't prioritize it. But then by the time you're 2 years down the line, you've accumulated enough of confidential information that you wouldn't want to be put out in the public domain, or worse yet, be given to your competitor. So you've
Yeah.
not thought about having those agreements in place.
But do you know what's interesting? Business owners, especially when you're first starting out, are not thinking about 5 years from now. Like, and I think this is a problem that businesses have, that you set up this business and you don't imagine, like, what happens if my business is wildly successful? If I have hundreds of clients or hundreds of customers and I have this business that's grown, and they don't think about that in the beginning. And that's where the risk is, right?
That is indeed a massive risk, and you underestimate what is your confidential information. In fact, there is also a distinction, I would say, going a level up between confidential information and intellectual property. And
Oh,
both these
yeah.
things need to be identified because they both add substantial value to your business.
100%. Now, if a business is thinking about drafting or implementing a confidentiality agreement, what sort of mistakes do you see that people make? Where do they run into challenges?
The number one mistake, and I say this very with a lot of honesty in my heart, the number one mistake that people make is entering into a confidentiality agreement with the wrong entity. So they'll sign the confidentiality with ABC Holding, but make disclosure to XYZ Trading. And ABC Holding would have said, you know what, XYZ Trading is part of the same group, so it's okay, just share that information. But if you are to make disclosure of your confidential information, especially where you're making disclosure of really sensitive information like trade secrets, you need to know the names of the people and the names of the entities that you're specifically disclosing information to. So, and this is something so basic, right? You would expect everybody could get this right. How could you possibly get this wrong? But you'll be surprised how people could easily get this wrong.
Well, I'm just imagining in my head as well, because a lot of times this happens when you're sitting around a boardroom table and maybe you've signed agreements and you're not thinking about the different company structures and who you're talking to, right? And so somebody's not going to sit there at the table and go, oh, excuse me, so I signed this confidentiality agreement, but it's with company ABC, but now I'm talking to XYZ. It's something that automatically wouldn't happen. And I guess you don't know if you don't know.
Yes. And you know what happens very many times, especially when you're dealing with family businesses in the region? They're all called pretty much the same name with just one word different: group,
Yeah,
holding, trading, delicacies, restaurants. So you just change one name, but they're pretty much all the same. So it can confuse you as well.
absolutely. Okay, so for people who are listening to this, I also want to kind of break down, because there's so many different types of confidentiality agreements, and depending upon what our relationship is, we should have different agreements, right? So how are they adapted for, like, you've got suppliers or partners or employees? How are they adapted? Because there's not one confidentiality agreement that's for everyone.
I would recommend break down your confidentiality agreements into either two or three types. So when you have employees working for you or consultants who are working either full time for you or exclusively on a project for you, or interns for that matter, have one type of document for them, because predominantly all the information that they create or work on is for you and your company. There is no way that they would use or adapt that information for any third party. They would not be allowed to do so because you're paying them exclusively for that purpose. So all the work product that they create is confidential to your business. So have one type of agreement with them. Then another type of agreement where you want obligations to be mutual. Everything is pretty much the same, fair
Right.
and balanced. A
Yeah.
third party, ideally, not employees, not consultants, not interns. So any third party that you want to disclose information to or receive information to. And the third type of confidentiality agreement, I would say, would be a one-way disclosure where you are the only party disclosing information, ideally to a third party, maybe for the purposes of them coming in to do due diligence into you. Maybe they are a prospective buyer into your business or a prospective investor, and you want to disclose information to them. So a one-way NDA or a non-disclosure agreement would help.
Right. Okay. Can you, because I know like all of the legal stuff can be quite confusing for people, would you be able to give an example of maybe a business where having confidentiality agreement has really helped them within business and maybe protected them from a negative situation happening?
I can give you so many examples. I've 20 years of experience in this country. We could easily run out of time giving you examples, but one very common example comes to mind, and this happens a lot, particularly with brokerages, with real estate brokers, with insurance brokers, any business brokerage, etc. They tend to have databases of clientele that they've either called or they've worked with or they've collated together. These databases of clients, typically, they've put together with consent, I hope so, from everybody on that list. And they've collated this information of their clients for a long time. So that data that they've collated and put together is typically their confidential information and should not be
Right.
downloaded or shared by any employees with any third parties. Now, there are two things that need to happen. One, you need to have robust confidentiality agreements with your employees to ensure that they preserve the confidentiality of that personal database with the same level of sanctity and security that your business does. And they have to be mindful not to share it with any third party. And the second thing that needs to happen is that you need to keep reminding them, because out of sight is out of mind. So even though you
Yeah.
sign the agreement, you need to keep reminding them. And I can't tell you how many times I have seen this happen where employees download databases and think it's okay to just download that data and take it to another company when they leave.
Yes. And you brought up something that's really important as well, is it's a constant communication with your employees and reminding them of that, right? Because you, it, people join a company, they have their first day or their first week or their first month, and there's the onboarding and they're learning everything. And then the confidentiality agreement is one of the many things that they're signing as part of the onboarding, right? And then it's just one of those things that gets forgotten about, and they shouldn't forget about it, but it is. So for us as employers as well, to make sure that that's something that's constantly reminded to employees about what is confidential, what you can share, what you can't share, all of these sorts of things as well.
It is very important to not just sign confidentiality agreements with your employees, but also in good faith to explain to them what you really
Yeah.
mean by confidential information and keep reminding them, at least through email reminders or stand ups or
Yeah.
training sessions, once a year, at least, so they are reminded and they know.
Absolutely. Okay, I'm going to break our Q&A for a second because the questions are coming in already. So one is from Veronique, and Veronique has said, how can we make sure that our NDA is enforceable, especially if the other party is outside of the UAE?
An excellent question, if you ask me, and we get asked this question all the time. This is, in fact, the golden clause of any confidentiality agreement. This is what makes or breaks your agreement. If you don't have a very good governing law and dispute resolution clause, your agreement could just be a paper tiger. It could very well not be enforceable. So the first clause you want to go and look at is your governing law and dispute resolution clause. And you want to think, if I'm based in the UAE and I'm signing an agreement with an entity that is based, say, in Kuwait, will this agreement be enforceable against them in Kuwait if a breach were to occur? That is how you should draft your dispute resolution provision, by keeping that particular scenario in mind. So I can't give you a ready-made dispute resolution clause now, of course. A little bit of thought
Yeah,
needs to be
yeah.
put into it, but that's the clause you need to look at.
And I guess it really depends as well on where that client or customer is based as well. And if it's, if it's a government-owned body, if it's a multinational, if it's a local one, because I've had that as well in my business, that I've had ones where the laws are very different if you're working with a government entity. The rules and regulations are very different if it was a multinational company.
Absolutely right. And it depends where the other party is located, who the disclosing party is, what is the possibility of a party breaching the agreement, is that sometimes the possibilities are just higher. And also, if you can keep a track of who they're possibly going to disclose it to, that would also be beneficial.
Absolutely. Now, I have another question as well from Sally, who is in Australia, actually. And Sally wants to know how we get confidentiality agreements when submitting tenders and have to give them all of our ideas. That's worldwide. Everybody struggles with that.
That's worldwide, and it's a very, very good question. Now, the one thing I would say is when you do submit tenders, do not submit information that would be considered your intellectual property. You don't need to, actually. You don't need to provide information that is sensitive. You can provide a general gist of what you can do as part of your proposal and say subject to signing a non-disclosure agreement. Or if you're going to submit information that you deem sensitive, you can always put a confidentiality disclaimer in there. Of course, whether it's enforceable or not is another question that we'll get to, but to the extent you can, do not disclose sensitive information in a tender is what I would recommend.
Yeah, absolutely. And that's a tough one a lot of businesses face as well, and I think that's quite right that you do say as well, is to be very careful about what things that you are sharing and maybe allude to it in a bigger picture, that when they sign that contract with you, that then you can give them access to all of that as well. Okay, Bianca, I have more questions for you, and everybody else, if you have more questions, pop them into the chat. We are very happy to answer everything. But I wanted to know from you as well, how much of a financial risk is it if a company doesn't have confidentiality agreements? Because I kind of alluded to it in the beginning, that especially with smaller businesses, as they're getting started, as they're kind of bootstrapping a little bit, that they're looking at it going, cost benefit. I'm weighing this up. It's not like if I have to look at paying a virtual assistant to help me or having a confidentiality agreement, I'm always going to be thinking about getting the virtual assistant. What risk is there to a business if they don't have things like that in place?
Let me flip this question around to you. Forgive me. And let me ask you, if you are a business, say you've been in business for 1 year, you've got a database of 100 clients who bring in consistent income to you on a retainer basis. An employee leaves, takes that list with them, and solicits all those clients, 50% of which go off with that employee. Would that be considered a substantial loss to you or not?
Yes. Yes, it would be.
In addition, your credibility just got put on the line because the clients have just been called by an employee that's left you. They've probably said things about you, causing reputational risk and damage. And now the client's questioning in the background whether they should continue working with you. So essentially, your entire client database has been put at risk. Your reputation is on the line. Can you possibly quantify that damage if you look at it as a small business owner?
No, absolutely. And it's one thing actually when I've had my other businesses as well, because I've had PR agencies, training companies, and that is one thing that I always made sure of, especially because I was using freelancers as I was scaling the business, that was part of the thing that was there for freelancers who work for me, employees who work for me, because that is, especially if you're a service business, but even if you're doing products, that's part of what is going to help you be running your business. And if you lose your clients or have somebody contacting your clients, that's a huge risk to your business and the future of your business.
Now, I do want to mention one thing to you. You could estimate a value to the confidential information you're sharing with your consultants, employees, or any third party working with you on a project. And you could put this estimate in your confidentiality agreements as pre-estimated liquidated damages. So they know that they have exclusive access to this information. And if there were a breach, you would know because this information is being provided exclusively to
Yeah.
them. Therefore, a breach would cost you X amount in damages. That's something you can agree in your confidential agreements that you sign.
Interesting. I'm going to jump back to our tender conversation because Veronique has a follow-up question. And she wants to know, is it the same when we deal with the government? Can we trust them? I guess it depends on which government you are dealing with. I think we all have stories.
Yeah, but look, unless the government or the entity that has, released the tender is providing you some form of assurance in the tender documents, no, you cannot trust anybody. But because we don't do business on the basis of trust, we do business on the basis of commercial agreements that we see. So if you want to provide information to an entity, you will either have to say to that entity, the information I'm providing to you is sensitive and confidential, and I request you to keep it as such, with the possibility that they may or may not adhere to that instruction, or limit your disclosure to that entity. What helps, I think, is also when the party issuing the tender provides you that reassurance or that confidentiality statement to say everything you give us is confidential. But it doesn't always happen.
The questions are coming in. They're on fire on LinkedIn. It's all over LinkedIn right now. The next question is, this is from Facebook. What is the recourse if someone breaks an agreement?
Again, let's go back to our golden clause to start with. A, we'll have to check to see whether the document is enforceable or not. Secondly, depending on the governing law, and the governing law is quite important here of your contract, you will need to measure the damage caused. Now, not all laws take into account moral damages, for example, or consequential damages. Laws like the laws in UAE only look at actual damages. So A, you will need to prove two things, right? One, this particular individual or entity actually breached the agreement. You'll have to evidence it. And secondly, you will have to evidence, under UAE law at least, what is the damage that was actually caused to you. Now, this may not be the case under UK law or Canadian law. So it really depends on the governing law. So it's very important to have a lawyer who specialized in that particular law or jurisdiction advise you at least on the governing law aspect and the enforceability clause of a confidentiality agreement.
And so would you say that, let's say, for example, a business in the UAE was signing a confidentiality agreement with a company in Kuwait or a company in the UK or Australia, that they would then need to also maybe get some legal advice for that country there to make sure that they're protected and the right jurisdiction and clauses are listed within there as well?
It gets quite tricky with a cross-border transaction, right? So the first thing I would look at is who is the disclosing party? Are both parties going to be disclosing information to each other? If they are, they need to agree to a neutral jurisdiction. England is preferred 9 times out of 10 as a neutral jurisdiction when it comes to cross-border transactions. That if one of the parties is going to be disclosing information, then ideally you want to be subject to the countries of the law that you're familiar with. So you'd want to favor your law. But as far as dispute resolution is concerned, you want to be able to enforce the decision with ease in the country where the other party is located. So it's really tricky.
Right. Yeah, absolutely. And that's why you need a lawyer as well. Just a comment from Aziza. Oh my, so many things. I'm so glad I'm going to learn more in your upcoming session. Aziza is coming to the workshop that we're doing on confidentiality agreements, so that would be great. Thank you, Aziza. I have a few more questions for you. We only have a few more minutes left because I know you are a busy lawyer and I wanted to grab just 30 minutes of your time. Can you let me know when we are doing a workshop on the 20th of May that is going to be on confidentiality agreements. Can you explain to people a little bit about what they can expect and what types of confidentiality agreements we're going to cover within that session?
Sure. I'm going to cover all the basics of what goes into confidentiality agreements, the three main types of confidentiality agreements that you typically have in the business. When you receive a confidentiality agreement, what are the landmines? What are the red flags? What are the main issues that you should negotiate in order to create balance in a confidentiality agreement for yourself and your business? And we are going to try and keep this session as compact as possible. So I know we've discussed before to try and limit registration so we can focus on all the attendees and their businesses and give them one-to-one advice as much as we can in that particular group. But the one thing that we also want to make sure that we give away is everybody leaves the session feeling empowered and being confident enough to be able to review any confidentiality agreement that comes their way without the need of going to a lawyer or feeling like they really need legal advice to know what to do next. Now, it's not going to replace legal advice when it comes to complex issues, but at least they'll be able to negotiate their own confidentiality agreements.
So, and I think that's really important that you say that. Like with everything in business, we have to be the experts in things, but we need to know what good looks like, and we need to understand what components should be there so we can ask for the right things and have an understanding of what's included as well.
Absolutely. Oh, I have a question for you, Jen.
Yeah.
What is the difference between a non-disclosure agreement and a confidentiality agreement?
Oh, an NDA. And you put me on the spot here. Gosh, I hope I pass. Do you know, I always wanted to, when I was younger, I wanted to go to school and be a lawyer. And I did not. I went into PR and communications and politics. So a non-disclosure agreement is an agreement that you have with another party, basically saying what you can and cannot disclose, what types of information can be disclosed or not. Where a confidentiality agreement, so an NDA, and tell me if I'm wrong, but I would say an NDA would be for specific pieces of information and you identify what that is, where a confidentiality agreement is a lot broader that will say things like, you know, it's like information related to this or these contact details, and that is not to be shared. You are not to go and keep that. Everything that you hear does not leave this room, so to speak. Am I right?
I love how much effort you put into explaining two concepts that are identical. So it's literally potato. It's the same thing, if I'm to be honest with you.
Oh, you were so horrible. You set me up. Because I have NDAs and I have confidentiality agreements. If you were going to set me up, why didn't you tell me this in advance, Bianca?
Potato. It's entertainment for the public.
Oh. But I gave good examples. They were both right examples of what it was.
You explained it so eloquently.
Yeah. Well, see, I would have an NDA be very specific, and I have NDAs where it's very specific about you do not reveal information about this.
Yeah.
Yeah.
It's essentially the same thing.
Yeah. Okay. So if you ask me again, I'll be like, hey, Bianca, it's the same thing. Why are you asking me?
So for our session on the 20th of May, I hope everybody
better know that.
You know that. Or I'm going to ask more fun questions. Don't worry. I always have fun questions up my sleeves.
Okay, so on the 20th, we are going to cover that. So people who are still like, I don't need that. I don't need to invest money. How much? Okay, so first of all, how much, if you went to a lawyer and did it separately of what we're doing with you guys, how much does it cost roughly? It's about,
I would say about 12 to 15,000 dirhams, depending on the complexity. And if you go to Magic Circle, international law firms, it costs much more and they charge in dollars as well.
So you're looking at like $4,000 to $10,000 as well. So it's, you know, it's expensive. So this is amazing that you're doing a super great deal for our Female Fusion members, but we're also we have limited spaces, but we've opened it up. So we have a few spaces as well for non-members to attend. So great deal. I know that Candice has shared the link in the chat. So if anybody wants, the link is in the comments as well. It's going to be on the 20th. It is a 3-hour workshop. And then afterwards as well, your team is also working with everybody and they get 3 customized confidentiality agreements as well, right?
Yeah. They can choose 1, 2, or 3 customized confidentiality agreements. It's going to be customized especially for their business. We're going to offer private consultations to them, and they can use it, whether it's cross-border transactions, whether it's in-country transactions. We'll take all that into account. It's really a workshop that I promise that will be power-packed and full of value.
Well, everybody knows Bianca, so they know it's going to be power packed and full of value. But it is amazing. And we see as well that a few people are like, oh, I didn't know it was on the 20th, so they can come. So Veronique, I hope we're going to see your registration to come in. We have limited spaces, so when they're filled, and that's it. But what a great deal. So thank you so much for supporting entrepreneurs, supporting female entrepreneurs, supporting female fusion. Any last thoughts or comments on what we're going to cover before we see you on the 20th, or any last takeaways that people should have?
Well, I would say start thinking about confidentiality very carefully. If you've got processes in your business that you want to keep confidential, if you've got trade secrets, formula, algorithms, documentation, statements, whatever you want to keep confidential, think about how you want to keep them confidential. The one thing I should mention that we will also be covering on the 20th of May is processes that you can put into place to protect the confidential information from a practical perspective, and also how to implement them. We are going to go a step further, and hopefully, if we have limited registrations like we've decided, we can focus on everybody's business and give everybody practical hands-on advice as well.
Amazing. I love that. Well, 20th of May, we will see everybody there. It's in the morning, so the link is in the chat. If you are a paid member of Female Fusion, just log into the members area because there's a super discount for members there. Just log into the members area and you can get the discount code there as well. So Bianca, thank you very much for your time today. And I look forward to the workshop on the 20th of May.
Me too.
Thanks, everyone. Bye.